Thank you for your stimulating presentation, Jan, and about the termination or not of the provisional application of agreements, free trade agreements, or trade chapters of association agreements. Very good. I have already these two questions. Please, Hervé.
Provisions of the CETA agreement and their provisional application. You said, if I understood well, that with the provisional application, rights of investor would still be applicable, those rights which are under the exclusive EU competence, if I understood well. You said also that the investor could use, therefore, not the ISDS mechanism, but diplomatic protection. I think you may have mentioned also that within the agreement, within the CETA agreement, there is an interstate dispute settlement. And my question is about that, about the possibility to use this dispute settlement as, if you look at Chapter 8, there is one provision which is interesting regarding that. It's Article 8.2.4. I don't know if you have the CETA agreement with you, but this provision is especially dedicated to this question of the rights of investors covered by the ISDS and also the interstate dispute settlement. So I think this provision would be applicable, would be the one applicable as, if you look at Article now 29.2, which is the scope of application of the interstate dispute settlement, it says more or less that all the provisions of the agreement are under the scope of application of this dispute settlement. I don't know if I'm well understood, but I think you could mention specifically those provisions. Now, I had one last question. It's regarding the denunciation of the agreement. As you know, regarding chapter 8, there is what is called a sunset clause, which says that if you want to denounce the agreement, the CETA agreement, regarding this chapter 8, you have a delay of 20 years of application. And my question is do you think this sunset clause would be applicable only with the provisional application of the agreement? Thank you.
Thank you. Can I ask you to repeat what provision, the first provision that you mentioned?
8.2.4. But I have it only in French. I cannot read it in English. I can read it in French, but I don't have the CETA,
that will not be
the English CETA
Have
version.
a look at it during Thank you.
Okay, I suggest that we collect some questions. Yes, yes, please.
Thank you very much. Just two quick points. First, on the provisional application of treaties, from a point of view of international law, I just want to stress one point, is that the International Law Commission of the United Nations, which is working on a codification of customary international law, is currently working on provisional application. And I had a very interesting discussion with the special rapporteur of the provisional application question. And the point of view of the International Law Commission is clearly that when a state withdraws its consent or explicitly states that it will not ratify the treaty, then the provisional application should stop, because the object and purpose of this provisional application is only to prepare the entry into force of the treaty. So as soon as the state states that it will not enter into the treaty in any way, then the provisional application will not be applicable. So
but they didn't say that regarding EU mixed agreements, of course. You're speaking about a classical case.
Yeah, sure. Yeah, exactly. But I mean, from the state part, I mean, from the part of competence that remains within the state, that may be interesting as well. So I don't know how it could be dealt with the mixed competence, but still the state of international law, well, I mean, this is the rule. So, but we'll see. Well, we'll see on that one. And just very, yeah, and just an answer to your question, Luca, at the end. I mean, what will be a solution if the ICS doesn't enter into force? I mean, and this is the risk. The solution will be the contract, and this is a real risk that companies and state get back to state contracts in which they will include arbitration clauses, and they have perfectly the right to introduce in the applicable law some provisions of the CETA which are quite close to customary international law as well. So, I mean, the risk would be that if they cannot enforce the rights with the international court system, then they will get back to arbitration and to arbitration based on contract. You know, so I think there is a risk here, and maybe part of an answer to your question. Thank you.
Comment, Wolfgang, please.
Yeah, some questions, but let me start with a brief comment about the sunset clause. There's a specific sunset clause with regard to investment dispute settlement. What happens with it if the CETA is terminated already on the stage of provisional application? There is a duration of 3 years, I think. Yeah, but there's a specific sunset clause in Article 30.6 or 7 addressing the issue of what happens if we terminate provisional application. It says that then you can only make claims which are valid for the period of provisional application for a period of 3 years after the termination of provisional application. But now, actually, to my questions. First of all, issue of provisional application under Article 218, paragraph 5. It always strikes me that the consent, there's no requirement of consent by the European Parliament, even though we have a requirement of consent in Article 218, paragraph 6. So that prompts to me the question, what is the essence of provisional application? Because when we look to international law, we have a mixed practice there. Sometimes we have an exclusion of, a limitation of provisional application to the extent that it is compatible with domestic constitutional and legislative law, as has already been mentioned. So I wonder whether one could not say, we draw the reverse conclusion from the non-existence of a requirement of parliamentary consent in primary law to the effect that the Council can only decide about provisional application to the extent that this does not require an alteration of EU legislation, which of course would be a rather new approach, because that is not what we think of. The other issue, actually it was a question raised by Pantaleo. Mr. Pantaleo, you asked when should we apply this 10 years period for bringing our claims under Article 19, paragraph 6. I think once we agree that provisional application does not comprehend this rule, we may not apply this 10 years period with the beginning of the provisional application. We can only apply it later, because otherwise we would say, well, actually, on a substantive basis, we would apply this rule even earlier. So there's a tension. That's why I don't feel we can apply it even earlier. There was one final issue. With regards to termination of provisional application again, of course, it's an EU law issue, and I fully agree with you that this must actually be done by the Council. But the problem now with CETA is that we, of course, has also a public international legal side of that, because the treaty says parties can terminate provisional application, and the German government says parties of a mixed agreements, that includes us. That was a point raised before the Federal Constitutional Court. And, in the end, the government said, we will take care that our right to terminate provisional application will be set and fixed also under public international law. And the consequence was that after the council decision was adopted, the German ambassador sent a letter to the Canadians telling that they have the right to terminate provisional application of CETA according to this declaration in the council, and the Canadians accepted. So we have more or less under public international law some indication that Germany could do it unilaterally. But I agree with you, there's a tension with the European Union law side. That's a tricky issue. I would like to listen to your view on that.
Okay, thank you. I think there are still two questions. Eleftheria?
I would like to ask or have a comment about the provisional application of the whole mixed agreement or the exclusive competence provisions only. I think if we think about the status of a mixed agreement, and we distinguish the question from the question to know if, in case of shared competence, the union can exercise it alone or not. This is a separate question. But once decided that the agreement will be mixed, then there should be no problem for a provisional application of also shared competence provisions, because if we say that only exclusive competence provision will provisionally apply, then it is like including in the, or rather linked to international law an union question, which is division of competencies. When a mixed agreement is concluded, even if there is a declaration of competence, there is no divisibility of the provisions according to the exclusive or shared competence. It's a whole. Then in the CETA provision application decision, it is clear that even if it concerns the whole agreement, the allocation of competence inside the union is not affected. So it means that there is a recognition of let's say, the status of mixed agreement as a whole in the international sphere, and while respecting the division of competencies concerning the application, which is an internal question falling under the loyal cooperation issue. And coming back to Luca's question about procedural provisions, I don't see why all procedural provisions should be concerned by the exclusion of investment court provision application, because if we see the statement of the Commission and the Council, they justify the exclusion from provision applications simply because it is something new, and they say there is still some public debate is not finalized in many member states, and they need time to see. It's not an ordinary provision liable to provision application. No?
Okay, Cécile Rapoport.
Yes, just a general comment to all the chair. It seems to me when I hear your contribution to your presentations that the determination of the scope of provisional application becomes more and more a political issue, because it becomes more strategic, because now, well, maybe that's probably the case before, but member state, I mean, the provisional application period could be used to evaluate the first effects of the agreement, and it could give arguments to national parliaments to decide whether or not to ratify the agreement. And so seems to me that it's more risky than it was before, and I wanted to, have your views about whether, well, how this political part, the strategic dimension is taken into account maybe in the determination of the scope of the provisional application.
Okay, thank you. I see that it was very stimulating presentations with lots of questions and comments. Would you like to start maybe to answer some or all of the different elements? Yes? But be aware that Jan will have also some time, so we will, I would say we'll stop at maximum at 1 or 5 to 1? At 1. Okay, so we have 10-15 minutes. Okay, very good. So 5 for you and 5 for Jan.
Right, thank you. It is going to be challenging. So I will start from is this on? Yes, from your questions. And unfortunately, I have to say that I did not manage to find the provisions you were referring to concerning interstate dispute settlement, even without finding it, I would say as a general question, as long as that is not excluded, of course, from provisional application, that is indeed a possibility of which investors, although only indirectly through their own state, may make use during provisional application, and is something which is a bit more advanced, so to speak, than simple diplomatic protection, of course. As far as the sunset clause is concerned, and this I will try to bridge two different comments. So there are several sunset clauses in CETA, one of which is indeed the 20 years one that you have mentioned. However, and that's Article 30.9. However, paragraph 2 of this sunset clause states, so I will read it, notwithstanding paragraph 1, in the event that this agreement is terminated, the provisions of Chapter 8, investment, shall continue to be effective for a period of 20 years. This paragraph shall not apply in the case of provisional application of this agreement. So I think that this can be interpreted as excluding, so at the moment, as of day one of termination of provisional application is terminated, and the rights conferred by CETA during provisional application will not be extended for 20 years. But this doesn't mean that claims referred to events that occurred during provisional applications will not be, so investors or states indirectly will not be able to raise such claims, as long as the events, of course, are covered by the provisional time of provisional application. There is another sunset clause that Professor Weiss was referring to, but that one has a limited, it's a very interesting one, because it is inserted in the context of a provision, which is Article 8 of Chapter 30, concerning termination, suspension, or incorporation of other existing agreements. Which existing agreements are we talking to? The agreements, bilateral investment treaties, which are mentioned in the provision, concluded by Central and Eastern European countries with Canada before CETA was concluded. Now, according to this provision, there is indeed a sunset clause, which states that investors may be able to bring a claim for a period of 3 years, even in the case that a provisional application is terminated, but it does not clarify whether or not that relates exclusively to these agreements. So if the territorial application, so to speak, of this sunset clause is limited to Central and Eastern European countries or not. Contextual interpretation would probably suggest yes, because it's a provision which is bang in the middle of an article that concerns only these agreements. So I would say that would be my answer, but there might be room for arguing other things. I agree with you also that another way to make up for the absence of a dispute settlement mechanism might be, so companies and states might be inclined to include arbitration clauses in contracts, and then they would resort to commercial arbitration as opposed to investment arbitration. So that's definitely a possibility. And then, last thing that I would say, otherwise I will speak for too long, so I will try to combine an answer to Professor Neframi and Professor Weiss' remark concerning the procedural rules. Now, my claim is that all procedural rules will not be provisional applied is based on the wording of the Council decision concerning provisional application of CETA, which we must assume will be replicated in the notification that will be addressed to Canada. And then, as far as Chapter 8 is concerned, the chapter on investment, it states essentially that only the following provisions will be provisionally applied. From Article 1 to Article 8, Article 13, 15, and 16. So essentially, from 1 to 16, with the exception of the provision on expropriation. Why? Because in Article 16 starts the part concerning the settlement of dispute. So everything else that is not included in the first part will not be applied, including the provision that I have showed in the screen, which will then, once the agreement enters into force, may raise the question of what happens to the events that have occurred during provisional application from a procedural perspective. So that's why I think they will not be provisionally applied.
Okay. Thank you.
Thank you for interesting comments and questions, which I will be happy to take on board for the final version of the paper. On the International Law Commission, that's of course extremely relevant. I really want to see to what extent they are taking into account the full complexity of EU treaty practice. That is also what the EU has called for. You know, the EU likes to make those statements in the sixth committee of the General Assembly when the ILC work is discussed. When they make comments, it's basically always to highlight the very special position of the European Union once upon a time on the draft articles on the responsibility of international organizations, but also this time with regard to provisional applications. And I guess that, for non-EU lawyers, even if they are very eminent, it's sometimes difficult to grasp the complexity of the EU. I have been struck by for instance, the reports of Sir Michael Wood on the identification of customary international law and the contribution that international organizations make to customary international law. He has, I think, done a rather good job in terms of seeing the contribution that the EU makes to customary law in its area of exclusive competence. But he too has a little bit the question of ambiguity. What about shared competence? So, I mean, yes, these are things that I think the ILC will continue to grasp and to struggle a little bit with. The other comments, the German letter, I would be very grateful for obtaining a copy of that letter. Well, that's now on record, so this is also being taped, everything is in the public eye. But I mean, I think it's interesting because these are beautiful things to analyze and to see whether indeed it is fully correct under international law. That's one thing. And then the relationship between international and EU law. I'm always in favor of looking at the things together and not separating them, as we sometimes tend to see in case law of the European Court of Justice. I think it's important to look at it from both sides, and we have a subsection on international law in Article 25 and so on. But I cannot definitively answer the question right now. I find it a problematic type of thing in substance, but I also think it's problematic that Germany sends unilaterally such a letter to Canada. I would be inclined, if I were the Commission, to take a little look at this from the viewpoint of the principle of sincere cooperation, something like that. I don't know. But I mean, yes, there is something, I think, strange and problematic in that. It would be interesting also to see whether there were other member states who have sent similar unilateral letters to Canada. Maybe there's even a letter from the Walloon Parliament. I don't know. This saga has given us incredible exposure for Wallonia in the world, I think. Eleftheria, your question is also very pertinent, and I continue to struggle with it. Yes. I have the impression that upon a reading of Opinion 215, the court seems to think that this is only for exclusive competences. Should we agree with that or not? Yesterday we had a very good presentation of Merijn showing all the various theories, confronting the court's reasoning with of the Advocate General and previous cases and so on. So it will remain on the table, but I fully share your view. And why does the Council always use that language of EU competence, union competence? They don't say exclusive competence. So, what should we ask clarifications, or would they just like to keep the options open depending on the case? Huh?
You even have the example of Colombia.
Exactly, the Colombia example. So I mean, yes, it's interesting, but it's inconclusive, right? And then, Cécile, I'm not sure I captured your question totally. What were you saying? You were saying during the period of provisional application, parliaments may use that period to evaluate the effects and the functioning of an agreement. Yes, they can always do so. But for what purpose? Then to finally decide on whether or not... Yeah.
Because it's a way to have a debate, a public debate at national level to decide whether or not it has so far had good effects or not on for the country.
No.
And they can, I mean, I know it's exclusive competences, but for public debates, it's just the setup or whatever.
I find it a very interesting point, but again, I find it problematic in the sense like, this is not meant to be a period for just waiting and leaning back and say, what are the effects, and now we bring it into the discussions.
I mean, if it's wrong, if it takes 2 years, I think we cannot avoid the fact that national parliament can use it as an argument to have a debate on whether or not they will ratify it. As a complete impact assessment,
Yes.
assessment, and
I see what you say, but to be honest, there too, I think there is something like sincere cooperation that applies to all member state organs, including parliaments.
A national deputy will
They will not care, of course. No, they will clearly not care. And I'm afraid that, this whole debate, look at the CETA saga, we haven't really highlighted this. But there's a lot of internal Belgian politics to that discussion, of course. In spite of the eloquence of Monsieur Magnet, there is a lot of internal political, and I'm afraid a little bit that indeed in many of those provisional application cases, it can either be about trying to use it to extract additional concessions from the other party, like what Italy did in the South Africa case, or it can just be political reckoning within member states or between institutions and member states and so on. So I'm afraid that very often this is very, very political rather than really legal.
I think we will stop here. I'm not going to take any other round of questions. We will have the lunch break. I would like to thank our two speakers and to thank you for your participation in the discussion.